Thank you. Welcome, everybody. Thank you so much for spending an hour midday with me. Thank you, Karen, for the introduction and the opportunity to give this webinar. This is kind of a follow-up one, although it's a standalone. I gave one in mid-April about essential estate planning documents, and I didn't go into trusts. So this is kind of backed by popular demand, but if you kind of look at the wheel there on the side of the different pieces of estate planning, you'll see wills, powers of attorney, advanced healthcare directive, trusts, and probate. We're not going to cover powers of attorney and advanced healthcare directives today. Those were covered in the last one, and my understanding is, and Karen, you can correct me if I'm wrong, but that was also recorded. So if you're interested, I'm not sure how that's accessed or how you're able to get at that, because I haven't looked at the Cook County Higher Ed site, but it's kind of a second part of a two-part series if you want the whole picture of the essential estate planning documents. So, but because of time today, I will be reviewing, as the title might suggest, wills and revocable living trusts, the basics. As Karen said, I practice with Matheson and Voss, and Lee Matheson retired. So she's of counsel to the firm. She's available to me, but not doing direct client work. So I split my time between Grand Marais and the Twin Cities, and I meet with clients all over pretty much the corridor between Grand Marais and the Twin Cities. So Lake County, St. Louis County, etc. So I grew up in Grand Marais, love to be back there part-time at least, and I love what I do. So I welcome this opportunity to give some information about these important topics. But that said, I want to make sure that you understand I'm not giving any legal advice today. So this is really just informational, kind of the basics, terminology, what the different documents do. So let's get started. Okay, why isn't it going here? Hang on. Yeah, I'm trying to get my screen to change here. My Zoom thing is right in the, I'm not getting it to advance. Hang on. Ah. There we go. Okay, I've got a menu bar right in the way. I wanted to start out with some common estate planning myths. I think it helps to kind of clear up, just make sure we're all on the same page as we get started, so that when we're taking in this information, it's clear what we're talking about. So these are myths. So these statements are all false, okay? Estate planning is not only for the wealthy. It's a common misnomer, is that, oh, I don't need to do estate planning because I don't have an estate. What's an estate? You know, I don't think I have an estate. Well, you do. If you own anything, a bank account, real property, anything, you have an estate that needs to be distributed in some way at your death. So it's not just for the wealthy. And another myth is that it's best done when you're seriously ill or dying. Believe me, I don't relish those meetings when I mean, they're necessary sometimes, and it's not that I don't do those, but don't wait until you're nearing the end of your ability to do your estate planning. That's stressful for you, and it's stressful for your estate planning attorney, and maybe that's not the best decision-making time. And another myth is that if your family knows your wishes, why do you need to spell it all out in documents? Well, you know, I guess I could say that even if your family knows that you want X to go to Y, they may not have the legal authority to transfer that asset. So that's another thing that estate planning does, and we'll go into that a little bit. I get a lot of questions about do-it-yourself estate planning. It can be a cheaper alternative up front, but you know, I have seen plans that have been done online that don't comply with Minnesota law, because every state has their own laws, and the online ones aren't necessarily state specific. So they might look valid, but when it comes time to do the distribution of the estate, they're missing elements. So I've actually had to charge more to fix something than it would have been to set it up economically upfront with someone that could give you legal advice. I'm having trouble with my mouse here. Hang on. I've got this screen right in front of where I need it to be. Okay. Some people shy away from estate planning because they think that they have to make everybody happy and they don't know exactly how to do that. So that's not necessarily necessary. And we're going to go through what probate is in a little bit, but wills do go through probate. So that's a common myth, is if you have a will, you avoid that court probate process. So here's a few more. And these will start to make sense as we go through the different aspects of these different documents in a little bit. But a trust is not a way to protect assets to having to be paid later for long-term care or nursing home stay or health needs or whatever. A trust does a lot of things, but it doesn't. We're talking about revocable living trusts today, and they don't shield your assets from having to pay for anything that you might need during your lifetime. And I think this kind of goes hand in hand with waiting until the end of life to do estate planning, thinking that, well, I don't, what if I change my mind? I don't want to, do something too early and then have to have it not be the way I want it. But estate planning isn't a one and done process often. Sometimes it is, but often I see people, updating their estate plans every 8 to 10 years or sometimes sooner. And we'll go through some of the reasons that you might want to update your estate plan. I didn't really do a poll to see how many have done their estate plan or who are thinking about it or whatever, but it's not a one and done process often. Things change, and so you can change your mind. And it's not one size fits all. If your neighbor or let's say your uncle or something tells you about their estate plan and they have certain documents in place, that might not be exactly the same thing that might be right for you. So it's tailored to your specific needs. The best ones are, let's just say. This is just kind of a funny one, but I get this question sometimes, and I think we've seen it in movies where there's a dark paneled office and leather chairs and people pulled up around the big desk, and the lawyer with the cigar in hand reads the will, and everybody finds out, who got what. Maybe that's a silly myth, but that's not really how it goes. There's no public or, reading of the will with the family. The personal representative, you'll find out who that is in a little bit, but they go over the will and understand what the provisions are and then move forward in distributing it. So sorry if you're looking forward to that dramatic ending. I guess I could do that if you wanted, but let me get to my next slide here. Okay, so let's define some legal terms quickly. You'll have the handouts. I'm not going to read you all of these, but there's a will and a revocable living trust. They're two documents that do the same thing. In the end, they distribute your estate when you're gone. But a revocable living trust does a couple of other things as well. It can manage your assets during your lifetime, whereas a will only kicks in at your death. As I mentioned before, an estate is all of the property that you own, including real estate and personal property. Estate has a lot of meanings, as we know. An estate can be a big house on a big hill overlooking a lake with servants, but that's only one type of estate. You don't have to have that kind of estate to do estate planning. Probate is the process of settling your estate after you die, including paying creditors and heirs and validating a will. Of course, you can't do that because you're no longer living. So that's your personal representative, that next definition there. They're the person that you name that is responsible for administering your estate, paying your bills, distributing your estate per your wishes, whether it's to your heirs or to charities or a combination of both, all of that. So there are many steps involved in that, but that's what that personal representative does. You might think of the word executor And that used to be the term. It's kind of an interchangeable term. Some states call it executor and some states call it personal representative. It's that person that administers your estate. In Minnesota, the legal terminology now is personal representative. And a beneficiary is a person or entity that is designed to receive property under your will or your trust or another asset. It's the recipient of an asset through some means. So maybe you're familiar with this. Maybe you have been a beneficiary of somebody's will or estate or life insurance policy or something like that. Okay, so I'm going to go through these will basics first. And for those of you, if any of you attended my last webinar through Cook County Higher Ed, this will be a review. But I didn't want to just do trust without wills because they're kind of the yin and the yang of the same purpose that we're talking about, is distributing your estate at your death. So what is a will? It's a simple way to ensure that your money, property, and personal belongings will be distributed as you wish after your death. It's something you create during your lifetime, obviously, by definition, and it spells out all these things. And a will allows you to appoint a specific person or persons to handle your estate at your death. Okay, little quiz here. What is that person called? I can't hear you, but I know you're all saying personal representative, right? Or representatives. You can have two working together. It doesn't have to just be one. It can be a shared responsibility. I see that a lot when people have maybe, you know, two adult children and one lives near and one lives far, but they want them to work together. That's certainly possible. The law doesn't require us to have a will. I like to bring up the example of Prince, who didn't have a will, didn't have a trust. It still astounds me that for such an astute business person, he did not have his estate planning done. I don't know. He had his head in the sand, I think. And so if you die without a will, Minnesota inheritance laws control how your estate is divided. And if we think about Prince's estate, it's going to his siblings and half siblings because he didn't leave a spouse or any children. And there's another sort of an odd result there, is that the inheritance laws say, if, you know, it goes to your spouse and children if you have a spouse and children. But if you don't have spouse and children, but you have parents that are living, it would go to your parents or parent, which can be an odd result. So sometimes that's, you know, people think, oh my goodness, I don't want that result. So it's a good thing to get your estate planning done, so your 98-year-old mother doesn't inherit your estate if something happens to you. Okay, what rules apply to wills? You have to be 18 years old at least and have the capacity to make a will, and you must intend for the document to operate as a will. So what are we talking about capacity? We're talking about capacity here. We're not talking about money. We're not talking about amount of stuff that you have. We're talking about mental capacity. And the testator, the person making the will, must understand the nature, the situation, and the extent of his or her property. I mean, this is pretty formal language. The claims of others on his bounty or his remembrance. Meaning that you need to sort of understand, you have to be oriented to kind of time and place, know who you are, where you are, and generally what you have and who might be likely to be inheriting that. You know, if you have kids, you need to sort of know who your kids are. And obviously most of the time people have all of this capacity, but if push comes to shove and someone's really nearing the end of their life or something, or dementia, or, you know, some sort of cognitive impairment, I've got to make this determination whether somebody does have capacity. In some cases, they don't, which is sad. So that's required in Minnesota. As you might just understand or know, the basic elements of a will would include your name, where you live. You know, I only do work for, I'm only licensed in Minnesota. So I can't do a will for a Wisconsin resident because I'm not licensed in Wisconsin. So that's why that's important. Any specific gifts you want to give to charities or individuals, you know, a dollar amount or a piece of property or whatever, and all those other things there that you can imagine are important. You know, who you are distributing things to, who your personal representative is. If you have small children, this is a really important thing. A reason to do estate planning is that you name a guardian for your minor children. Who's going to take care of those kids if you or you and your spouse are both gone? And who's going to manage the money for those kids that you're going to leave behind? As much or as little as you would leave behind, someone needs to establish the responsibility for taking care of that money and taking care of those kids. So those are some of those elements. And some of these words that are used in wills are legally operative. You know, it sounds like family or, you know, other words that are common usage in our conversation might be legally binding words, but that's another thing that, you know, wills do that are, you get some legal advice so that the wording is correct. And so it's clear to the court what it is that you're trying to accomplish. So information needed to prepare a will, and this is really similar to trust. So we'll get to that at the end, but this kind of applies to both. You know, really starting with your objectives of how you want your assets to pass at your death. And what it is that you have, right? We're kind of going back to that will definition is, what do you have and who do you want to pass it to? So those are some of the important precursor information things that you need to do before you prepare a will, is to sort of understand what you have and think about how you want it to pass. And often everything passes to your spouse at the first death. What we're really thinking about is if you're married. So if you're not married, or you're thinking about what happens if, you know, you and your spouse don't survive, then who does it go to? The kids, if you have children. If not, where does it go? So we're looking for a list of your family members and other individuals or charities you wish to receive your assets. It doesn't have to be locked down tight before you really establish that or talk to someone about your goals, but it's good to have a list so that we're all talking about the same thing. That family tree is important. Showing the relationship and who the children are of whom, and if you'd want them to inherit if that parent didn't live. You know, we kind of go down the steps a little bit in terms of where that inheritance would flow. And this is really common, and I think a lot of us don't want to discuss the problems in our family tree. But I don't think I've met a normal family yet, and I don't think I belong to one. So I'm pretty sure that everybody has some family members that we're concerned about, or someone on the tree that maybe couldn't handle an outright inheritance. Is there anybody we need to plan for so that that money isn't seized by a creditor or subject to addictive behavior or protected from a divorce, things like that. So all of that, as hard as that might be to talk about, the best estate plan is done when all those things are on the table and all those things are understood and talked about and concerns are shared, so that there are ways to protect against people maybe getting an inheritance before they're ready for it. Just like with minor kids, you know, what would an 18-year-old, I'll put myself in that, what would I have done with a big inheritance at 18? You know, I probably would have had some nice clothes and a nice car, but I don't think I would really have any of that today. So there are ways to protect against access to money over, you know, to ensure that maybe a minor would have access to money over time and not receive that full inheritance until a later age. And I've seen later ages up to 65 because the parents say, I want to provide a good retirement for this person who is not able to save for retirement. So anything's possible. So what are the responsibilities of a personal representative? So when you're thinking about who you might name as your personal representative, that person that would administer your estate at your death, I always just say it's not necessarily a position of honor. It's a working position. Someone has to have some financial abilities. They don't have to be a CPA or an accountant or anything like that, but they should be able to keep a checkbook and, you know, pay bills on time and follow paperwork through and make sure that accounting is done appropriately, so everything is appropriately distributed. And, you know, who sometimes might do that job? Well, if you have responsible adult children, that's great. If not, maybe you have a trusted friend, something like that. It's also important to think about the generations of people here. So if your brother is like your go-to person, that's great, but you want this estate planning document to follow you throughout your life. And you can always update it to update your, you know, naming your brother if your brother becomes, you know, too old really to do the job. Or you could have someone that you trust and then a backup, name a successor or a backup personal representative. So maybe of a younger generation. So thinking about who those trusted people might be, you know, a bank or, you know, like in Grand Marais, there aren't any banks that do trust work, but in Duluth there are. So some people who really don't have any other options name a bank to do that work. And of course they would take a fee to do that type of work. So talking about changing or updating your will, it's effective when you sign it. It lasts forever. They don't expire unless you know, revoke it. You can cancel it. So it is important to review it periodically because you may have someone named in there to act or someone to receive assets that you no longer think is appropriate. So you do need to update those kinds of choices. But here's some of the things that might precipitate you taking another look at a will that's already been created. Your marital status changes. You get married, you get divorced, your spouse dies. Those are times to update your estate planning documents. Or at the birth of a child. You don't have to update it necessarily every time a child is born. We usually put language in there that says, you know, and any children born after this date. But if you don't have kids and then you know, start a family, it's good to add that guardianship clause or whatever. So that's a good time. And as I mentioned before, the death of a beneficiary of your assets or a change in mind of who you want to receive your assets, or maybe the percentages that you want to distribute change. If you move to another state, it's a good idea to get your will reviewed or your trust or whatever, because every state, as I mentioned, has different laws. So if you've moved into Minnesota from another state, it's best to, and you have an estate plan, it's a good thing to get that reviewed to make sure that it still represents what you want, and it would do that in the state of Minnesota. Or if your assets change significantly, that's, you know, you inherit something from your parents, or, you know, there's a lot of real estate bought or what purchased or whatever there, you know, it might be a good time to update, change your estate plan, or at least look at it. Goes without saying. Or if there's a change in the law. I haven't seen too much of that, but, you know, anytime I update someone's estate plan, I always look to current law to make sure that everything is up to date. How am I doing on time here? I'm pretty good. So probate. Think of probates as kind of going together with wills. It's the legal process to transfer assets held in your name alone that doesn't have another beneficiary designation on it through your will, or through the Minnesota intestate statute provisions if you don't have a will. So I guess the easiest way I can explain this is in Minnesota, if you die with like real estate in your name alone that's not in joint tenancy with a spouse or whatever, or if you have it in something called tenants in common, you own a share, maybe with siblings, of hunting property, and there's no way for that to transfer, your ownership to transfer, you'd have to go through a court probate process, even if you have a will or don't have a will, to make sure that, to ensure that then somebody has the authority to sell that on your behalf. Or any like bank accounts, financial accounts that exceed $75,000 in your name alone, that has to go through a court probate process to ensure that, you know, it goes properly, the proper people are appointed to administer your estate, etc. And any state you own property in likely has to go through probate. So if you have that piece of property in your name alone, or piece of that, a piece of property, a part of a parcel. Let's say, I mean, we have a lot of people in Cook County or all throughout Minnesota who have maybe a winter residence in another state. So we'll get to trusts in a minute. But yes, if you died and had real estate in Florida, let's say, and Minnesota, you'd have to go through a probate in Florida and Minnesota to transfer that property to whoever it is that is set to receive it, either through your will or through the intestate statute. And what isn't subject to probate? Things that aren't in your name alone because it's held in joint tenancy or held, you know, like a joint bank account, or something that has a payable on death designation or a beneficiary designation like an IRA or life insurance. Those are often, the majority of the time, they have a beneficiary designation, or if you have real estate subject to a transfer on death deed. I am going to take a little pause here because there might be some questions, and before I get into trusts, but just I'm going to cover this slide and then I'm going to take a pause and see what questions have come up from Karen. Maybe Karen can help me out there. So if your assets are less than $75,000 and you don't have any real estate in your name alone, there's something called an affidavit for collection, and you would take that to the bank or to the financial institution, and your personal representative or someone in your family would to collect that asset. I know I went through this kind of fast, but I want to make sure to get to trusts. Karen, do we have questions that have popped up before we get to trusts here? Maybe everybody.
We do not have any questions. We had one question, but you answered it in the course of your presentation.
Show of hands, is everybody still awake? That's, you know, just kidding. Oh yeah, okay, I got it. Thanks, Jill, you raised your hand. Okay, Jill's awake, so we're not, I'm gonna keep going. And Bill, okay, good. I'm just kidding. I know I'm going through this stuff really quickly, but I've just got an hour, so I wanna get to, because that was sort of review, I wanna get to trusts here. Okay, the way that I look at, I'm a visual learner, so I like a graphic or a diagram to get my head around a concept. And for me, when I talk about a revocable living trust, I like to think of a bucket. And why do we think of a bucket? Well, it's a way to hold our assets. We put assets in the bucket and we still hang on to them because we're the owner of that bucket. But at some time in the future, we pass that bucket off to our successor for them to manage that asset, or like in a will to distribute that asset per instructions of that trust. So I think a bucket analogy is a good one in that it holds assets. And if I had the ability to draw a faucet out of this bucket, the faucet would show how the assets travel out of the bucket and to your beneficiaries. So that's kind of what I think of as a trust, is a bucket. There are a couple of kinds of trusts. There's many kinds of trusts. I'm mainly going to cover revocable living trusts today. But when we were talking about wills, back a few slides, and we were talking about, let's say you have minor children and you are naming a guardian for them should something happen to you or you and your spouse, you know, both parents. Then in a will, a trust is created for that inheritance for those children until they become adults. So that's called a testamentary trust because it's set up through a will. It doesn't take place during your lifetime. It's only set up contingent upon your death and to fund the support of your children throughout their childhood, and then it distributes out to the kids at a certain age, whatever you specify out in the future. So other than that description, we're going to set aside testamentary trusts for today and talk about what's on the right-hand column there, revocable living trusts. And these aren't created at your death. These are created during your lifetime. You create that bucket during your lifetime. You're the creator, and you're the manager of that asset. And we'll get to some of that terminology in a minute, but you'd be the creator, the settlor, and you'd be the original trustee. And you title assets during your lifetime. When you set this up, it's best practice to title those assets in the trust so that they're managed by you as the trustee, and they're managed per the terms of the trust. And we do that in a number of different ways. For real estate, we deed it into the trust, into your name as trustee of the trust. For bank accounts, those things that might otherwise be a probate document or a probate asset. Remember, we talked about the things that might be left in your name alone. Those are the things we're looking at to put in a trust, so that the trust, you don't have to go through probate that way. We'll get to that. I'm getting ahead of myself. But we retitle those assets in the trust by use of some documentation. So, and it can be changed just like a will. It can be changed or revoked during your lifetime. It's an estate planning tool like a will, but it has extra bells and whistles, as you might think. Okay, hang on, I gotta change my, there we go. So it's an estate planning device like a will, and it provides for asset management in the event of your incapacity. Remember now, a will, I'm gonna keep comparing and contrasting here, a will doesn't kick in until your death. So there's no lifetime management of your assets through a will. But through a trust, let's say you're incapacitated and you cannot manage your own assets anymore because you just don't have the mental capacity. Whoever you name as a trustee to follow you as trustee of your trust can do that on your behalf during your lifetime and really step into your shoes financially. So that's an advantage. And it's still like a will, it provides for the distribution of assets at your death. And it can provide provisions to delay the distribution of assets to minors or others needing financial management of assets, similar to that testamentary trust we just talked about. Even if it's not being created through your will, as I said, if you have family situations where you're concerned about somebody's ability to manage an inheritance of any size, they could either get their inheritance outright, or you can hold it in the trust over a certain period of time. Maybe you've had this in your family, you know of someone who can draw on trust assets for what they need, but they don't have access to the whole amount until they reach a certain age. So the trust has the flexibility to do that. And if funded properly with those otherwise probatable assets that otherwise might be left in your name alone, trust avoids a court probate procedure to transfer your assets at your death. And this is what I find is one of the great advantages of a trust. I don't know if any of you have gone through a probate process with a family member. There's nothing wrong with it. It's just a delay. There's delays and there's a lot of paperwork to do, and it's over time. It probably takes about a year to distribute everything out of a probate process. You see probably those notices in the paper. If you're really bored and are reading the fine print on the last couple of pages of the paper, the notice of the probate is out there for creditors to make their claims against the estate, etc. And they have 4 months to make claims. So that's part of the delay of distributing assets, just as an example. The other great thing about a revocable living trust, I think, is it's private. You don't have to go through a probate process. And it doesn't have to be filed with a court. So nobody can go take a look at your will because it's a public document that you could go request a copy of at the courthouse. And there's no probate hearing. So there's no public reading of it. There's no public sharing of that document. And for some people, for whatever reason, that's an important aspect of estate planning. They don't want nosy people to know what it is who they gave their money to, or in what percentages, or what charities they supported, or what provisions they had for their kids in there. And again, just to reiterate, it can be changed, amended, revoked, just like a will. Like any other estate planning document, it can be changed over time. Just a little, we talked about the rules that apply to wills, so we'll talk about the rules that apply to a trust. It's created if the settler has to have capacity, as we talked about, and they have to have the intention to create the trust. Same thing with a will. It has to have a beneficiary, and the trustee has to have duties to perform. Kind of a formal way of saying you have to intend to create a trust and has to have a beneficiary. It can't be you. That's not a valid trust. If you put money in a trust and it comes back to you, it has to have a different beneficiary than the creator. And the capacity is the same as that to make a will. You have to be 18 or more years of age who's of sound mind. And then the purposes can be created, a trust can be created for any legal purpose. So I'm going to leave that there. There's a whole bunch of things we could talk about there, but in general, for estate planning purposes, that's a legal purpose. So I alluded to this a couple slides back, but there's kind of some other terminology that we talk about with a trust. The creator of the trust is called the settlor or grantor or donor. It sounds like the wild, wild west, like I'm settling my homestead claim. But the settlor, just the creator, is the way you think about it, or the grantor. And you transfer the property from you as the owner of it outside the trust to the trustees of the trust, the person or persons who hang on to the bucket. And most of the time that's you. If you create it, often you're the you're the trustee because you want to retain management. Let's say you wanted to create a trust and you don't want any management of it. You can have a different trustee of your trust. I've done that occasionally, but in general, you know, a revocable living trust is often done with the settlor being the initial trustee. But you name a successor trustee. Remember this, they can act if you're becoming incapacitated or at your death. So the corollary here would be like your personal representative. So your successor trustee acts when the initial trustee can no longer act due to incapacity or death. Or if that, let's say that initial trustee is a trust company, if they resign, there's a successor to them. And the trustee, their job is to hold that title to the property in the trust and manage the trust property for the benefit of the beneficiaries. Let me make clear though, that if you're the trustee of someone else's trust, you don't get the assets yourself. You know, when it says that they hold the title to the property, they don't hold it individually. So if you're the trustee, let's say someone says, oh, I've named you as my successor trustee. That doesn't mean that at their incapacity or death, you're going to take ownership of their assets permanently and have to manage them for them. You're only holding those as trustee or as a successor trustee. You don't take personal ownership. So it doesn't affect your taxes or any of that or your ownership. So I'm going to kind of speed through this one because it's very similar. What kind of information do you need to gather if you're thinking about preparing a trust or talking about preparing your trust? Your objectives, again, of how you want your assets to pass, an inventory of your assets, right? A list of your family members, your family tree, or charities that you care about that you wish to receive assets at your death. Information about your family, again, spouse, children, grandchildren, stepchildren, and you can omit people. I guess I didn't bring this up before, but maybe there's someone in, you know, maybe if there's a family member that you don't wish to receive assets, for whatever reason, you can omit them. And we like to spell that out in the trust document or in the will document so that that's clear. Sometimes you're omitting a child because they received all of their inheritance during their lifetime. Maybe they got the family business. Maybe you supported them through a bunch of creditor issues and you feel that that really constituted their inheritance. You can omit people. Again, any concerns you have about family members and their ability to handle distribution of assets. Again, your choice for successor trustees. It can be your kids. It could be a trusted friend or relative. It could be two people acting together, or a professional trustee, such as a bank with trust services. So similar to wills. How am I doing on time? Okay. What are the duties of a trustee? Well, we talked about that a little bit. So if you're thinking about who might act as trustee, here's kind of a job description. Okay, here's something to think about. Is the person I have in mind sort of up to the task? They're set to a high standard of care in respect to trust assets. If, you know, one of your kids has an axe to grind axe to grind against two others of your kids, maybe they're not the best successor trustee, because you want to make sure that they are coming into it with an open mind and a fair standard of care to all beneficiaries. And they have legally prescribed duties. So if they aren't doing, if they're not doing things fairly, or if they're not acting per the terms of the trust, the other beneficiaries can hold them accountable by in a lot of different ways, but they're protected by law. They have legally prescribed duties. And as I said, act in the best interest of the beneficiaries and to manage the trust assets prudently. And they're responsible for the distribution of assets per the trust terms. Now, a trustee can't be forced to becoming a trustee just because they're named in the document. So I've seen this happen. Someone is named as trustee and they're just heading overseas for a deployment or maybe a job assignment in Kuwait for 2 years. Well, guess what? I can't be the trustee. So they just say, I can't do it. Who's the successor? So they don't have to. But it's always a good idea to ask people first. Don't just surprise them by naming them as trustee. And the court, if there's really nobody set to act and nobody that's willing to act, the court can appoint a trustee. Of course, you want to avoid that. You don't know who the court might nominate or appoint. So, I've seen trusts with 3 or 4 successor trustees. It's a good idea. Then you've got some backup. You don't have to change your trust every time you change your mind about, or if someone ages out of the task. So I'm just going to close with some advantages and disadvantages of a trust, and then a little comparison chart about wills and trusts, which is kind of a review because that's what we've kind of gone over here. So the advantages of a trust, and I should just preface this by saying I don't have a preference for a trust versus wills. I'm not saying that I've got, a horse in either race that I'm rooting for. It's just it depends on your situation, and one tool might be better than the other. So the advantages of a revocable living trust is that during your lifetime, it kind of has some incapacity planning built into it. It provides for financial management of your assets if you can't due to incapacity. Now, some of you might be thinking, if you came to my last seminar, well, what about the power of attorney? Isn't that what that does during your lifetime? And it's true, very astute. If that was your thought. A power of attorney document during your lifetime names someone to act for you financially for things if it were outside a trust. Inside a trust, it's only a trustee, but it's not as strong. That power of attorney document is not as strong a power as a trustee is. So I'm just going to leave that there. But if you were thinking, are you stuck if you're incapacitated and don't have a trust? No, in that case, hopefully you're relying on a power of attorney document that you've created. Otherwise, you'd have to probably get a conservatorship or guardianship to pay your bills for you. Another advantage of a trust is that it's private. Remember, we talked about it doesn't need to be filed with the court. It avoids the time delays and costs associated with probate. And if you have real estate in more than one state, you can have real estate from more than one state in a Minnesota trust. So in that case, as I mentioned, we're with our snowbirds who have property in more than one state, or maybe you have hunting land in another state, you can make sure that you don't have to go through probate in more than one state by putting everything into a Minnesota trust. And then the trust would determine how that passes no matter what state it's in. So that's like a nice little benefit of that. And again, of course, it can be amended. And the disadvantages. Well, you have to do a little work up front to ensure that your assets that don't have a beneficiary designation, like IRAs or life insurance, etc., you title those in the name of the trust, or in other words, put those into your trust bucket, right? Title them into the trust bucket. And that's done with some paperwork or a deed that transfers it to the trustees of that trust. Again, not in their name personally, but their role as trustees of the trust. So maybe you're, I won't go into that, we don't have time. So it may be a little bit more involved to set up initially than creating a will, but it's less expensive to administer than a probate of a will after death. So the setup is a little bit more, but the administration at death is very simple. You don't have to wait. Nothing has to be published in the paper. You don't have to wait for any creditors claim period because creditors aren't noticed in that way. You just have to pay the creditors that you know whose bills are there for the estate, etc. And here's that comparison chart that I wanted to leave you with is, you know, wills and trusts do the same main purpose of distributing assets at death, but trusts add that provision of some lifetime management of assets because you pass the bucket off to that new bucket holder who's the successor trustee, and they manage your assets for you during incapacity if that happens, or sometimes people are never become incapacitated. They maintain their capacity until death, and then that's when that trust bucket gets handed over to that successor trustee, and then they can immediately start gathering the assets and distributing out to whomever the trust specifies receives the assets. They don't have to wait through any court process, etc. So I think that's pretty clear. I want to make sure that I leave a lot of time for questions. And as I said, there are some other protections, important legal protections. This power of attorney and advanced healthcare directive, those are kind of part and parcel of what you need during your lifetime to make. The power of attorney is for financial decisions on your behalf, and advanced healthcare directive names someone to make healthcare decisions for you if you are unable to during your lifetime. So, and again, those were covered in my last webinar that Karen can confirm that that was recorded. So whether it's available now or will be available in the future, these two together would give you that whole graphic of the essential estate planning documents. So let's think, is that the end? Yes, questions?
Okay, we have a couple of questions on the Q&A. The first goes back to wills, and it was a question about something you said, and it said, a parent doesn't inherit ahead of children, does he or she?
No. Okay, yeah, I probably covered that a little quickly, and I'm sorry for that. If you have a spouse, it's a little complicated if your children aren't all the same as you, and if you have other children besides, if you have a mixed family, let's say. But in general, talking in general, your spouse and children inherit first. And if you have spouse or children living, it doesn't go anywhere else if you don't have a will. Again, this is that Minnesota intestacy statute. But like in the case of Prince, he didn't have a spouse and no children. So they had to find where the next closest family member was. And in this case, before it went to the siblings, it would have gone to parent. Parents are closer than siblings in terms of the Minnesota intestate statute as next of kin. So that's when it would go to parent if no children and no spouse.
Okay. The second question is, what's the average cost of retitling individual assets into the trust? For example, real estate. Yeah,
the average cost is, there's a filing fee with the county. I can quote that, it's like $47.65 for property for a deed plus the state deed tax, the minimum state deed tax. It's really, you're gifting it. So there's no, it's the minimum deed tax, which is $1.65. And, it's all just kind of part and parcel of what we do estate planning wise, but a deed, I would say that you could transfer it over for, $200 or less, probably. And it might be just rolled up into the whole estate planning costs. So somewhere in there.
Okay. Next question. Do you ever have conversations utilizing an LLC versus a trust to pass down a cabin?
Yes. Yeah, cabin trusts aren't part of this webinar. And see, last time I started talking about a different thing, then I got signed up to do another webinar.
Yes.
So no, I do a lot of cabin trust LLC work. So that's a different animal, but yes, I do. That is common, is to figure out, does an LLC fit you better or a trust? And it just depends on a lot of different factors. So yeah, cabin trusts are an interesting type of trust.
All right. I hope we'll have you on again. Can a trust be jointly held by a couple, then passed to beneficiaries only upon death of both?
Yes, yes, there are. There are joint trusts. You know, things I couldn't get to today were estate planning based on the estate tax, any estate tax exposure. So I do a lot of joint trusts. The estate tax exemption in Minnesota right now is 3 million. That might change because now we're in a deficit. We've been in a surplus for a long time. That's a topic for a different time. But in general, if we're not doing estate tax planning, a joint trust works just fine. And as you might expect, as the question said, nothing is distributed until both of you die. So it's a joint trust. Everything goes to the spouse at the first death, and then at the second death, that's when it's distributed out to beneficiaries. So good question.
How much are property taxes increased when you put real estate into an irrevocable trust?
Well, we didn't talk about irrevocable trust today. This is revocable. Irrevocable means you can't change it. And so what we're talking about today is revocable. Your property taxes don't change. You can still homestead, or you often have to just reapply for your homestead property taxes because they see that it's been transferred. But as long as you're still living there or a relative is living there, you're still qualified for homestead. So there's really not an impact at all on property taxes.
Okay, those are all of the questions that we have. Wait, one more. Oh, two more. This one we always get. What is an average cost for a will or trust?
I know that's so hard because remember it's not one size fits all. So as soon as I say what it is, then someone comes to me and goes, well, you said it was this, and then they have everything is different. So, and I don't just mean to be hedgy, but what I would say, I guess, is a trust plan can be probably about twice as much as a will plan. And this includes, you know, the power of attorney and the healthcare directive and all the pieces you need on either one. It's not just the will or the trust. They kind of come as a little set. So maybe a will and power of attorney and healthcare directive for two people, let's say that was in the $1,000, $1,200 range, somewhere in that range maybe. And a trust might be twice that much. But a probate, and we didn't talk about the cost of probate, but a probate proceeding, if you have a will and have to go through probate later, of course, it wouldn't be during your lifetime, but a probate proceeding, those are starting now. I mean, I estimate at least $3,000 for a probate proceeding just because of the time involved and the different paperwork and the different segments that have to happen. So that's kind of part of the trade-off is a will might be less expensive to set up front, and more expensive later to administer. And a trust, when you distribute that, because you don't have to go through court or whatever, it's much more, there's some paperwork involved, but not nearly to the degree of a probate. And I will say that I do work with people. I don't turn anybody away because of affordability. So that's another reason I don't really want to quote rates, in that I work with people. So you know, and this isn't a commercial for me, but I know a lot of attorneys do this too, is, you know, we'll work with you to get you what you need.
Okay, we have two more questions.
Okay.
How is it best to handle title bank accounts? For example, have a payable on death provision or Title I bank account as a trust account so as to avoid probate if necessary?
You know, that's hard to answer without knowing the specifics. And you know, and I don't want to give any legal advice here because it's not a pat answer. There are situations where a payable on death designation might work on a bank account, and avoid doing a trust, but depends on, you know, like an example might be you have a payable on death to 7 kids on a bank account, and it all goes out to 7 kids. Well, then who's going to pay the debts of the estate? You know, and now everybody's gotten their distribution, but who's going to pay the bills? Everybody's got to then ante money up back into a pot to pay for funeral expenses or medical bills or whatever, and that can be problematic. I mean, that's just one example of why a payable on death might not be the best for distributing your assets at your death. That one's just kind of hard to answer without a specific scenario, and given time I could, you know, put a couple of scenarios together, but you know, with the time we have available, I'm just, you know, I guess I would just say it would just depend on the circumstances.
Okay, I know we're running out of time, so I'm going to, we have 3 more questions, but I'm going to just tell everyone, while everyone is still here, that you can see the recording of this and of Ruth Ann's previous presentation on our website, mycche.org, and look under the Lifelong Learning tab, which is under the Learn, on the Learn page. And you can see all of our recordings of our webinars. And so if it's okay with you, Ruth Ann, I'll go ahead and ask the last 3 questions. And
sure. The other thing you can see on those webinars is how much my hair has grown in the last month. And if I do another one, my bangs will probably be down to here. So it's a good record of the COVID-19
it is
shutdown.
That was exactly a month ago, April 14th.
Was it?
Okay. Yeah, I know. Okay, can my brother's portion of an inheritance be designated into a trust?
Without more information, I can't answer that question. I mean, if you're giving something to your brother, I mean, if a trust isn't set up ahead of time, we'd have to talk about that. I mean, if there's something that's going out to him, that's kind of beyond the scope of what I can answer without more information. I'm sorry.
Okay. Can you avoid probate if all your assets are joint ownership and there is still a separate person assigned as a financial guardian from the beneficiary?
I mean, I never try to predict who's going to die first. So people say, oh, there's no problem. It's, you know, I have everything in joint tenancy. Well, what happens down the road for joint tenancy is one person dies and then it's left in that other person's name alone. And it's no longer in joint tenancy if that person has died. So even if, let's say, you own something in joint tenancy and you leave it, let's say it's a piece of property and your husband's name is still on it, although he's died, that's no longer joint tenancy. Even though it's titled as such, that other tenant is not living. So maybe I lost the thread of the question there, but so, I mean, it's possible, but just know that as people pass away, then that's how something becomes a probate asset and left in one person's name alone. Or maybe you both die together, you know, in a common accident. Then that has to go through probate because there's no owner of it. There's nobody that has the authority to take title to that and distribute it. Did that make sense? Did I answer that question fully?
I think you did.
Okay.
The last question that I have so far is what is the cost of putting your home in your adult child's name?
You know, there are so many pros and cons to that. I don't want to answer that because the costs are, I mean, it can be as easily as just you know, creating a deed kind of similar to transferring something into a trust. But I mean, to me in my head, there's a big red flashing light going on that you can't see that says, oh, but there are so many things to talk about before you do that. A lot of people think that is the golden ticket and to, you know, put things in your kids' names, but there are a lot of considerations to think about. So that's about all I can say there in the time available.
Great. Well, I'm going to pop back on so people can see me. Thank you, everybody, for joining us.